We are grateful to President Trump for his commitment to uncovering the truth in this case. Oh, gosh. Is Ghislaine going to get a pardon?
The president has said if the Department of Justice and the FBI want to move forward with releasing any further credible evidence, they should do so. As to why they have or have not or will, you should ask the FBI about that.
What they did in 2016 and in 2020 is very criminal. It's criminal at the highest level. So that's really the things you should be talking about.
The DOJ now springing into action on the Epstein and the Ghislaine Maxwell cases. We see a new statement from Pam Bondi shared ultimately from Todd Blanche on X, and we've also got updates. Remember that Pam Bondi and the DOJ submitted motions to unseal the grand jury transcripts and testimony, and we've got orders now from the judges on both cases. We've got this Ghislaine Maxwell case where the judge issued a 4-page order explaining the DOJ needs to submit some more stuff, and we got this one in the Epstein case. Of course, he's dead, and the case is closed. Ghislaine is still on appeal, but here we got another decision and order from the judge as it relates to what is needed from the DOJ to unseal the records. But we also know the DOJ is now going to be attempting to talk to, interview, depose, meet and greet with Ghislaine Maxwell. And her team is confirming the conversations are happening as well. Here's the statement. Todd Blanche said this, Pam Bondi sharing it. This Department of Justice does not shy away from uncomfortable truths, nor from the responsibility to pursue justice wherever the facts may lead. The joint statement by the DOJ and FBI of July 6 remains as accurate today as it was when it was written. Namely, that in the recent thorough review of the files maintained by the FBI in the Epstein case, no evidence was uncovered that could predicate an investigation against uncharged third parties. And now it's maintained by the FBI. Like, you see how they introduce, like, this is narrowing their statement a little bit. The original statement back on July 6th was pretty broad. Now it's like maintained by the FBI. Okay, well, does the CIA have a bunch of emails? Does the DNI have a bunch of emails? Does Homeland Security have a bunch of emails? No evidence was uncovered that could predicate an investigation against uncharged third parties. And this is the new discovery evidence doctrine, this idea that the only way, and we were critical of that July 6th memo, part of the conversation is that it forecloses any future investigations. Okay, it was very final. It was conclusory. It's over. We looked. You're done. Nothing else to see here. So how do you walk that back is what we were saying. Like, oh gosh, like she just did a disservice even to the next administration. Anybody else who wants to come in and dig into this a little bit further, Pam just exonerated them. Unless, like, the only out on that strategy is the discovery of new evidence. Oh, we didn't see it. Which, of course, has the downside of making you look incompetent. Like, why didn't you go do and investigate that before? Now, President Trump has told us to release all credible evidence. If Ghislaine Maxwell has information about anyone who has committed crimes against victims, the FBI and the DOJ will hear what she has to say. You know, well, you could have talked to her like last week, you know, or July 5th before you released the memo. So therefore, at the direction of Attorney General Bondi, Todd Blanche says, I have communicated with counsel for Miss Maxwell to determine whether she will be willing to speak with prosecutors from the department. I anticipate meeting with Miss Maxwell in the coming days. The Deputy Attorney General is going to go meet with Ghislaine. Until now, no administration on behalf of the department had inquired about her willingness to meet with the government. That changes now. And we know why it's changing is because there's still a lot of public pressure, rightfully so, on this case. They tried to post and move on. Post the memo and move on. You just post through it. You just keep working through it. You're under attack. Just keep going, baby. Just keep driving. You're going to be okay. And they tried it. Didn't work. So now they're changing things. Okay. And that's all good news. Incredible. But we also got Todd Blanche responding to this as well. He says, justice demands courage. And for the first time, the Department of Justice is reaching out to Ghislaine to ask, what do you know, Ghislaine? At Bondi's direction, I've contacted her counsel. I intend to meet with her soon. No one is above the law and no lead is off limits. And so this is a curious situation happening now. Kash Patel says, get it for your contribution. We also see Caitlin Collins is reporting on this one. Ghislaine Maxwell's attorney called David Oscar Marcus is now telling CNN, Caitlin, I can confirm that we are in discussions with the government and that Ghislaine will always testify truthfully. We are grateful to President Trump for his commitment to uncovering the truth in this case. Oh gosh. Is Ghislaine going to get a pardon? So they're going to deliver something and they're working a deal, uncover the truth. Ghislaine is innocent and Epstein did all this and we'll see what happens. Or immunity. Are they going to grant her immunity in exchange for the truth? And Epstein's dead, allegedly, and she's out if that happens. Oh gosh, I sure hope not. We see here in the case of the United States of America versus Ghislaine Maxwell, the court responds, Paul Engelmeyer out of of the Southern District of New York, writing the following: the court has received a 4-page motion from Pam Bondi called the United States Motion to Unseal the Grand Jury Transcripts. This was filed on July 18th, as we read here. Now, the motion asks that the court unseal the underlying grand jury transcripts and that they would have victim-related redactions. Now, the court intends to resolve this motion expeditiously. We're not waiting around. However, the court cannot rule on this without some additional information. Here's what we want. Now, Federal Rule of Criminal Procedure 6E codified the practice older than our nation itself that proceedings before a grand jury shall generally remain secret, right? And this is like the standard rule. Highly protected, highly institutionalized throughout our entire system of law. Rule 6E3 lists exceptions to the rule of secrecy, but these are not invoked by the government's motion, right? We read that. We said, yeah, so now they're saying there's a kind of a sub-exception that the Second Circuit has recognized. So there are, quote, special circumstances that are not in the rule that the Court of Appeals in this district has said, well, even though it's not in the rules, like, we're going to still allow you to do it, in which a release of the records is appropriate based on the court's supervisory authority over grand juries it impanels, right? So in other words, the federal rules of criminal procedure, we'll say, are set by statute, right? So Congress will pass the rules that the courts follow, but the court is not going to say that, we don't have any inherent powers that we can use. And that's what they're using, right? We're under the Constitution, we have supervisory duties, and so we have to be able to do certain things, and if we think it's in the interest of justice or whatever, we can do it. And courts always find these little exceptions for themselves. The rules say you can't do it, but we can. Saying the discretion of a trial court in deciding whether to make public the ordinarily secret proceedings is one of the broadest and most sensitive exercises of careful judgment that a trial judge can make. And the Second Circuit has identified the following non-exhaustive list of factors for district courts to weigh in considering applications for disclosure. Saying who is seeking disclosure, the identity of the party. Well, the government, DOJ, Pam Bondi, Todd Blanche, the American people. Whether the defendant to the grand jury proceeding or the government opposes it. So does Ghislaine Maxwell oppose this? We have not seen anything from her yet. We'll see what she says. She's still alive for the time being. Hopefully the video cameras are on in that cell. Why disclosure is being sought in the particular case, and this I think is kind of a weak justification. I mean, I'm not saying that our interest is weak, but legally speaking, public interest is not a strong basis for doing anything legally. Of course, we don't really care what the public thinks about any of this, generally. Now, what specific information is being sought? How long ago the grand jury proceedings took place? A long time ago. The current status of the principals of the grand jury proceedings and that of their families, so what happened to the jurors? The extent to which the desired material, either permissibly or impermissibly, has been already made public, so you don't need it. It's duplicative and not necessary. Whether witnesses to the grand jury proceedings who might be affected by disclosure are still alive or dead. Whether there is an additional need for maintaining secrecy in the particular case in question. So whether the government or whether somebody can maintain an argument for that. Generally, that's the government making that argument, right? But the defendant might as well, or other victims might. So you might have other people say, well, I don't want my name in there. You have one victim who just says, I can't have any of that coming out because I could be identified. And the court can say, well, there's still people here who don't want it out. Now, the government's motion does not adequately address these factors. The court accordingly directs the government to file a new memo, do a better job this time. You brought up the Second Circuit and then you didn't even analyze the indicia, the different factors that are in there. So do it again, no later than Tuesday next week. Addressing with specificity these and any other factors the government views as germane to its application. The memo of law, no more than 25 pages, double space. We'll read it. In light of grand jury secrecy and victim-related issues, the government is authorized to file on public record a redacted version and then under seal, unredacted. The court also directs the government to state in the memo whether before filing the motion, counsel for the government reviewed the transcripts and whether the government provided notice to the victims of the motion to unseal and notice to the victims who then, of course, can lodge an objection. Following the court's ruling on the motion, the court will invite the government's input as to whether and to what extent the redactions are warranted. Now, they say the court has not received the grand jury transcripts that the government seeks to unseal. He's like, I don't even have them. So the court directs the government to submit to the court under seal the following materials: an index of the Maxwell grand jury transcript materials, a brief summary, the number of pages and the dates, a complete set as well of the transcripts which are in their possession, and a complete proposed redacted set of the Maxwell grand jury transcripts, the transcripts in the form the government wants to release them, right? Because the government presents the evidence to the grand jury. It's their case. So they have all of it. They just can't give it to us because the court keeps it under seal, keeps it protected under grand jury protections, which are very strong. So a description of any of the grand jury materials, including but not limited to exhibits. Now, we also need to know what Ghislaine says. The court has not received a letter by or on behalf of Ghislaine. What is her position vis-a-vis the proposed disclosure? Any such such letter is due by her on Tuesday, August 5th. So not a lot of urgency here. The government may not have notified the victims, and the court has not received any letters on behalf of the victims setting out their positions via the proposed disclosure. And so if you're a victim and you want to say something about it, Tuesday, August 5th is your deadline, signed by Paul A. Engelmeyer, the judge. And so honestly, that's kind of calling out the DOJ's memo. It's like, you guys were really sloppy on this. You didn't even give us a solid memo. And I got that vibe when we read it here. It's just kind of like, well, we have to kind of ask for this in public interest. And even though we think we did an amazing job and there's nothing here, like they're still screeching about it, all these peasants out there yelling at us, go get the records. And so we're doing that. And so we're kind of begrudgingly submitting this into the court. I mean, I think Todd Blanche's original motion to unseal was like 4 pages. As you can see here, 4 pages. So the judge is saying, where's your analysis there, Todd? Give us some more in here, okay? And put some oomph into it this time. So I have a basis to actually unseal these things. We'll see if he does. We also then saw in the Epstein case. So this one is now Richard M. Berman, United States versus Epstein. We got a new order from this judge today. It's the same jurisdiction. And so we don't know if these judges just copied each other's homework or what, but here's what this judge said. All right, in the case, United States of America versus Jeffrey Epstein, and even the format of the order looks different, doesn't it? Maybe it's just a stamp. No, it's different. It's even a different header, right? So the judges are not even on the same templates over there. All right. So the court has received a 4-page motion to unseal. This is the Epstein case. This case is mostly dead and closed. Here is what the latest activity was up until recently. 2019, sealed documents, because he's dead. The case is closed, okay? So we just got activity on this, woken from the dead. July 18th, motion to unseal. Now we got the order back from the judge. Here's what it says. And the government is now requesting unsealing. Now we're going to resolve this one expeditiously as well, but I can't rule. They copy and pasted each other's homework. It says the rule of criminal procedure 6E says special circumstances, and you have to give us details on the indicia that the Second Circuit said are relevant to our analysis, Todd. Now the government's motion does not adequately address these. The court accordingly directs them to refile this, no more than 25 pages, double space. In light of grand jury secrecy and victim-related issues and other personal information, you can file a redacted version and file a real version under seal. The court also directs the government, before filing this, and counsel for the government, to provide notice to all the victims and whether what redactions are warranted. Now, the court has not received the grand jury transcript in the Epstein case, and so just like with Ghislaine, they want copies of it all, an index of the materials, a complete set of the transcripts, a complete and redacted set of Epstein's grand jury transcripts that you want to release. So the full set and the set that you're going to release, and a description of any other materials, including exhibits. Now, we also want, this was our question, so Ghislaine has an opportunity to object, but the court has not received any letter on behalf of Epstein setting out any position vis-a-vis the proposed disclosure, and so Epstein's estate could theoretically object to this, I guess, and the judge could take it into consideration, and victims as well, saying the court has also not gotten any letters from victims. Any letters due by Tuesday, August 5th. This is a 2-page, undated, unsigned DOJ investigation memo, writes this judge. According to the government, Epstein harmed over 1,000 victims. Gosh. Each suffered unique trauma. Sensitive information related to these victims is intertwined throughout the materials. This includes specific details, such as victims' names and likenesses, physical descriptions, places of birth, associates, and employment history. So ordered by Richard Berman, U.S. District Judge out of the Southern District of New York today, July 22nd, 2025. Now, these judges are both democratically appointed judges. So this is the Epstein judge, Richard Berman. He was appointed by Bill Clinton, assumed office on September 11th, 2011. And this judge is the Ghislaine Maxwell judge, and he was appointed by Barack Obama, and he assumed office in 2011. So we'll see what these judges do. We'll see what the objections look like, of course, when they come down. Marjorie Taylor Greene, meanwhile, says, if you tell the base of people who support you of deep state treasonous crimes, election interference, blackmail, rich, powerful, elite, evil cabals, then you actually must take down every enemy of the people. If not, the base will turn, and there's no going back. Dangling bits of red meat no longer satisfies. They want the whole steak dinner, and we're not accepting anything else. And Tim Burchett was also out today saying, looks like it's official. We're going to subpoena Ghislaine Maxwell, which is an interesting development. So Todd Blanche is going to go and speak with her, presumably, and maybe Ghislaine comes and testifies in front of Congress. Woo, baby. All right, here's what Tim Burchett has to say.
Hey, everybody, Tim Burchett.
What's up, Tim?
Oversight Subcommittee, Government Operations. Asked some questions about the GAO, their bid process, but the important thing was did a motion to direct the chairman of the full committee to authorize and issue a subpoena for Ghislaine Maxwell to appear before a deposition. That's it right there. to. I had it printed out, so I made sure I do it appropriate. Talked to Chairman Comer. He's down with it. We're good. I believe he's going to issue the subpoena. He's a stand-up guy. We just got to get to the bottom of this thing, folks. It's just 4 years. You know, we don't need to tolerate this stuff anymore. Yeah, and I get the blowback about folks up here going to be mad at me, but ultimately, with all sincerity, I'm answering my creator on this issue and what we did about the least amongst us. And we got to send a message to these dirtbags that do this. This is not acceptable behavior. And also a message to the victims that we believe you and that you need to come out of the shadows. We need to bust these people that do this and send them to hell, because I'm over it. Anyway, before I get myself in any more trouble, thank y'all for sending me here.
Thank you, Tim. So he's absolutely right. If there's 1,000 victims, did Epstein and Ghislaine go and recruit every single one of those individuals, or were there other people also invested in this operation and enabling it and actually paying out hundreds of millions of dollars to settle with the victims who they helped to transact? Talking about JP Morgan. Caroline was asked about this yesterday. She had a brief conversation with the press about these records.
The president just ordered the FBI to release the full Epstein files, just get it all out there.
The president has said if the Department of Justice and the FBI want to move forward with releasing any further credible evidence, they should do so. As to why they have or have not or will, you should ask the FBI about that. It's up to the Attorney General.
We'll see what happens with Pam. Trump also got asked about this today.
Mr. President, do you support the Justice Department seeking a new interview with Ghislaine Maxwell? Did you urge the Attorney General to seek?
I don't know anything about it. They're going to what? Meet her?
Deputy Attorney General has reached out to Ghislaine Maxwell's attorney asking for a new interview.
Yeah, I don't know about it, but I think it's something that sounds appropriate to do, yeah.
Do you have any concern, Deputy Attorney General, as your former attorney, would be conducting the interview, given
No
past
concern. He's a
relationship?
very talented person. He's very smart. I didn't know that they were going to do it. I don't really follow that too much. It's sort of a witch hunt, just a continuation of the witch hunt. The witch hunt that you should be talking about is they caught President Obama absolutely cold, Tulsi Gabbard. What they did to this country in 2016, starting in 2016, all the way going up to 2020 in the election, they tried to rig the election and they got caught. And there should be very severe consequences for that. You know, when we caught Hillary Clinton, I said, you know what? Let's not go too far here. It's the ex-wife of a president, and I thought it was sort of terrible. And I let her off the hook, and I'm very happy I did. But after what they did to me, and whether it's right or wrong, it's time to go after people. Obama's been caught directly.
Right.
So people say, oh, you know, a group. It's not a group. It's Obama. His orders are on the paper. The papers are signed. The papers came right out of their office. They sent everything to be highly classified. Well, the highly classified's been released. And what they did in 2016 and in 2020 is very criminal. It's criminal at the highest level. So that's really the things you should be talking about. I know nothing about the other, but I think it's appropriate that they do go.
All right, so Trump kind of standing aside, it sounds like, to allow the investigation into the Epstein stuff and Ghislaine to continue, and the interview likely happening soon. And Todd Blanche has to respond to both courts, and we'll see if those files get unsealed. We'll stay updated here. Thank you for subscribing and joining as we do.